of the IPC. If we have Nabila with us, she'll take you through the rest of this broadcast in just about a bit. But that's the big story that we are tracking at the moment. Endgame sedition law. Supreme Court going on to say, keep all the cases in abeyance, stay all trials until sedition law, examine sedition law first. That's the big story that we're bringing to you. Let's get you some reactions that are coming in from prominent journalists, coming in from prominent activists, from political parties as well, because this is a defining observation made by the Supreme Court and a big game changer coming in really. Nabila is joining us, my colleague. She joins us from the studio for all the very latest and will walk you through the rest of the broadcast. Nabila, we do know that there have been so many prominent cases, whether it is popular journalists, some activists, very high-profile sedition cases also. And this gives them slight bit of a relief at the moment, and it's a landmark observation coming in from the Supreme Court, of course, putting the ball in the central government at the moment.
Right, Chaiti, this is surely a landmark observation, considering that sedition law, as the court has observed, many governments in the past, be it the central government, even the Maharashtra government, in the latest, where the Rana couple were slapped with sedition charges, it seems like now some kind of relief for those people who have been booked under sedition law. In fact, the Rana couple in the latest also appealed against this charge in court. But it seems like now the Supreme Court has observed that sedition law has been largely misused and that the central government now must review it and try and understand what provisions must be allowed under the sedition law and what must be reworked. Of course, this comes as a big relief to all those people who have been booked under the sedition law. Many journalists, like you said, have been booked. In fact, we're looking at the sedition law. So far, many cases have not been able to get bail. They've been seeking bail, but none of them so far have been able to obtain bail, considering the sedition law has been so harsh. But now it appears that the Supreme Court has decided that until the central government reviews the sedition law and comes out with a response, this law will be kept in abeyance. Those who have been already booked under sedition law can seek bail from court. In fact, they can approach court to seek bail, and that comes as a huge, huge relief for those who have been booked under sedition law. Now, we know that 3-judge bench comprising Chief Justice of India, N.V. Ramana, Justices Suryakant and Hima Kohli, have in fact said that petitioners have raised contention that if grant is adjourned, then how to protect the interests of people who are already booked under Section 124A. And on this petitioner's observation, it appears that the court has now decided that all those cases who have been booked under sedition law, they now can seek bail from court. It seems like a big relief for many, many of those people who've now been, who are arrested, who languish in prison under sedition charges. Now, let me quickly cut across to Sanjay Hegde, senior lawyer, joining us on the phone line. Mr. Hegde, thank you very much for your time. Here, it seems like the Supreme Court has observed that there's been large misuse of the sedition law. And it appears that the Supreme Court now says all those cases that have been booked under sedition law, many of those people now can seek bail, and also observing that this largely has been a problem. What exactly has the court observed today?
See, the court has effectively put the law in abeyance. As far as it has also requested both the center and the states and asked the center to give an advisory to the states that please don't have any fresh cases lodged under this section while the section itself is under review. As far as cases already lodged are concerned, if there are people in custody, it has said that they can approach the appropriate court for bail, and those bail applications will be heard reasonably expeditiously. So the effect of the court stay is to keep the law on hold till Parliament takes an appropriate decision and a review of the matter.
Right. Mr. Hegde, we do know that there have been several journalists, several activists, several, now in the latest, the Rana couple, politicians as well, who've been slapped with sedition charges. And this, the court has observed that various governments, be it the centre or even the state government of Maharashtra, has possibly misused the sedition law. At this point, this law be kept in abeyance. Do you think this has come as a setback to many of those parties that have used sedition law to arm twist?
Absolutely. See, the delightfulness of the law was that it was so delightfully vague. Disaffection against the government by law established. So you may like a government, you may not like a government, you may say something for it, then there is no problem. But if you say something against it, or even if you say something which vaguely hints at disaffection, you could come within the ambit of the law, which had a very harsh and indefinite sentence. You could be sentenced up to life imprisonment. You must remember that the Congress government in Chhattisgarh actually got a conviction, that the government in Chhattisgarh, sorry, not the Congress government, but during the UPA era, the BJP government in Chhattisgarh got a life sentence confirmed for Dr. Binayak Sen, who had been helping several people in the tribal areas. So this law is overbroad, very vague, and it would have, given the nature of today's constitution, would have been struck down. But for the fact that there is an earlier judgment of the Supreme Court 60 years ago of a 5-judge bench, which said that the law can be held to be constitutional if some very strict guidelines were followed. Now, this guidelines procedure has not really worked in implementation. The court would have proceeded to take a call on whether the earlier judgment needed to be overruled by a larger bench, and then the law struck down. But in the meanwhile, the government has said that we are taking a relook. I would think that given the fact that there are many other sections of the IPC which can be applied to almost any set of circumstances, this is an extra law which serves no real purpose except being a convenient tool for tyranny. Maybe the government itself can just take a relook and say, we really don't need the law. Let us abolish it altogether.
Right. Mr. Sanjay Hegde, thank you very much for joining us. But it seems like successive parties that have come into power so far have not been able to largely review the sedition law. The BJP government this time has agreed to review it. It seems like this has come as a major relief for many of them who've been booked under sedition charges. They can now seek bail. Let me cut across to Advocate Shamshad, a senior lawyer, joining us on the phone line. Mr. Shamshad, this does come as a massive relief to many of those journalists, activists who've largely, under various governments, been booked under sedition charges, have been languishing in prison, not been able to seek bail. How do you observe this judgment by court asking for a review of Section 124A within the next 3 months?
See, I feel this is a great relief for all those who have fought against this law. This was initially brought by the Britishers, as we all know. But the way all the governments, I am not saying this or that, but all the governments have abused this successively. And they never realized that this kind of abuse of law will certainly sometime attract the attention of the court to intervene. And this day has come today. Though it is a little late, in any democratic system, this kind of law has no place. But though it may be late, but certainly it is a welcome move.
Well, surely it's a welcome move, but does this come as a setback, Mr. Shamshad, to various governments? In the latest, we saw the Maharashtra government arm twisting the Rana couple, who are politicians, with the sedition charge. At a time like this, does it really teach a lesson to those political parties who are trying to misuse this law?
I think differently. See, these all, everybody who is in power now, they are ultimately citizens of this country. And this this law is certainly not in consonance with the democratic principles of any civilized country. Those political persons who feel that they are, custodian of democratic principles to be followed in the country, and the citizens need protection in terms of constitutional spirit, then they should realize that this is not the law which should be used at all. And if they feel that that this is setback, then I can't say that because I feel this law has place at all in a democratic system.
Right. A quick word, Mr. Shamshad, just for our viewers to break it down. What exactly is sedition law? And if you are booked under sedition charges, how heinous is this crime?
Sedition law is that if you have disaffection to the country and the nation, then certainly the government will act. Now what is disaffection? That has no definition with sufficient definitiveness. There is no sufficient definiteness in defining what is disaffection. So if I am making certain statement against somebody who is in power or against some institution or whose functioning may not be good according to the citizen, then the party in person, the party in power or person in power may take a subjective opinion to say that a statement of this person is disaffection, and that's why 124A should be invoked. That I have committed some crime by raising this statement against the nation, and the consequence of this is that you may be subjected to life imprisonment. So even a simple statement, which according to me may be my democratic right, may be my right in guaranteed by Constitution, but the person who feels my statement is not suited to him may brand the statement as disaffection, and I may be subjected to in court of law, and finally the process will go on and on and on, and I will remain in jail for many years. So that itself is very drastic process, and ultimately few of them reach at the final stage when the conviction and sentencing are also done. So that's the consequence of this.
Mr. Shamshad, this sedition law that's been slapped against several activists, journalists, even politicians in the latest. It's almost become a fashion, a trend of sorts. Multiple parties, various state governments, the central government at large have used sedition law. Naysayers or critics may say only to suppress voice. While on one hand, the lines are so blurred, one can put out a message, say for example on Twitter, a message that they believe is freedom of speech, while the government of the day could look at it as bigotry. So this could be largely misinterpreted, and that, it seems, is what exactly the court has observed.
That's right. That's what every activist, every sufferer, every victim has been telling to the system, not only court but to any other organization or institution who is dealing with it. See, the apathy is that the Britishers who brought this law.
Yeah, they've abolished it. United Kingdom has abolished it. It's 150 years old law. Yeah. And who were they? They were imperialists. They wanted to control the system, the country, the people here with very, very serious, extraordinary power, which had no place in a democratic system. And that time there was no democracy. So now the moment this transformation of the system took place from an imperialist power to a democratic system, that time itself it should have gone. But it remained because the people in power did not want to dispense with this power. Yes.
And the reason may be, yes.
You know, it's interesting to know that this law was extensively used by the British in the pre-independence era. So we're looking at freedom fighters, several freedom movements that were quashed through this sedition law, including Mahatma Gandhi, Bal Gangadhar Tilak were among those prominent leaders who managed to go to jail under this law. So when we're looking at that tradition of this law, should it not have been revoked much earlier than now?
That's right. That's right. It should have it should have gone immediately upon promulgation of Constitution of India in 1950, if you analyze it correctly. But for whatever reason, as I have mentioned earlier, it has remained on the book. But see, if it was on the book and it was not abused the way it has been over the period of time, probably the voice would not have come so much. But now, because the people who are there and feel that the statement of people are inconvenient to the establishment, so they start not only using it but rampantly abusing it, which can be reflected from the record. So this abuse has brought this attention of the court, and this is perfect at this time. Though certainly it is a little late, but welcome move.
Sure, absolutely. It is late, but a welcome move because, like you said, and it's shocking that one can go into life imprisonment if convicted under sedition law. Has there been convictions, though, Mr. Shamshad? How far have the government been able to prove that the person who has been arrested under sedition law is indeed guilty of that crime?
There are two parts of it. There are two parts of it. One part is once the charges are slapped and the charge sheets are filed, the person is inside jail, and the process that we have, there is no accountability that that in how much time charge sheet will be filed, how long the trial will go on, how long the appellate courts can keep the matter pending to finally decide the matter. So that process itself sometime may go on for 10 years. And during that 10 years, if unfortunately he doesn't get bail, then his life imprisonment is served. Now, second aspect of this is that, see, finally how many convictions take place. Most of these charges ultimately ends up in acquittal. Many of them, majority of them.
But after years of struggle, and fight and money spent.
But the process itself is so cumbersome and
yes.
Difficult that the process itself becomes conviction here. So that is the problem. If you fix a guideline that during in 6 months everything has to conclude, and if the charges fail, then the person who slapped these charges will face the consequence. Probably the abuse will come down. But we don't have that accountability in the system.
Right.
That's
but
the unfortunate part.
Mr. Shamshad, let's be very clear that this is not acquittal to any of those people who've been booked under sedition charges. This is only the law kept in abeyance. They can, of course, seek bail, but it's not acquittal. You agree?
See, right now, as I have heard from the reports, right now, no fresh charges can be, fresh case can be registered. But as far as those cases which are pending, the judges will take appropriate view on that, considering the fact that the Supreme Court has kept, for future, this provision under abeyance. So technically, yes, those cases which are registered or are pending has nothing much to do about today's order, but certainly it will have some impact on those matters also.
Right. Right, Mr. Shamshad, thank you very much for your time. India Today, of course, has brought this news first to you. Sedition law has now been kept in abeyance. Those who have been booked under sedition charges now can seek bail. It comes as a big relief as the Modi government has now decided to review this law, which is at least 150 years old. Successive governments failed to do so. It appears that this government showing some intent. We're going to continue tracking those developments. A short break for now.